Hearing the appeal of foreign application of Afzal and Iyieke against the Secretary of State of the Home Department.
Yes, Mr. Jeffrey.
My Lords, good morning. I appear in both appeals, assisted by my learned friends Mr. Rahman and Mr. Broachwaller in the appeal of Afzal, and by Mr. Rahman and Mr. Hingora in the appeal of Iyieke. The Secretary of State is represented in both appeals by Ms. Giovanetti, King's Counsel, and Mr. Key. My Lords, there have been some further documents that have been sent by email over the past couple of days. I just wanted to check that my Lords have received them.
Yes, I think we have everything. The latest was a guidance document on biometrics that came this morning.
Yes, I think there was a letter relating to biometrics. Sorry, a letter relating to the payment of the fee in the immigration health surcharge sent by the Home Office, sent, I think, yesterday afternoon.
If you can give me just one moment.
Are you able to tell us what the title of that file would be? Because we've had them put in a bundle for us.
My Lord, I will...
Is it applications for leave to remain, validation, variation?
No, it just says Afzal, 18th October 2017 letter.
That's in the file, is it?
No, that one hasn't reached us.
I apologise for that, my Lord. It was sent by the Secretary of State. It might not have reached because it was sent, I think, fairly late yesterday afternoon. If I'm not mistaken.
We didn't send it to the court.
Oh, it hasn't been sent. Do we have hard copy? Do we have hard copies? My Lords, I can send an electronic copy myself just now, if that assists.
Well, if you could send it to our registry, they'll forward it to us. Should get to us quite soon.
I'm grateful, my lad. I apologise for that. It's a missing document from the documents from 2017 in relation to Afzal. I'll come on to that as I get into the submissions. My Lords are aware of the issues, 4 issues before the court today. I'm proposing to deal with them in the order that they're set out for Afzal first, and to deal with Iyieke's issue last today. So I wanted to start with the Section 3C issue. Both appeals, of course, are appeals against in judicial review proceedings, appeals against refusals to grant permission to proceed with judicial review claims. Both applications were applications for indefinite leave to remain on the grounds of long residence. Both appellants have leave to remain and had leave to remain at all times. The only question was whether they had qualified for indefinite leave to remain. The core issue in Afzal is whether the book-ended period of leave is counted, and the issue in Iyieke is whether the book-ended period of leave of 111 days, which is not considered lawful, comes within the disregard provisions in 276b5. In relation to Section 3C, if I could take my Lords first of all to the decision under challenge, which is at 143 of the bundle, and I'm referring to the electronic bundle at all times, my Lords. That is a decision of the 11th of March 2020, and the substance of the decision begins at page 83. It sets out the immigration history and the relevant rules, and then you have the reasoning at 84.
I'm so sorry, I missed the page number. Could you
84, my Lord. That's the substance of the reasoning.
The 84 in my bundle seems to be an extract from the Court of Appeal.
I'm sorry, it's 146. I'm looking at the central numbering. It's 146. I do apologise.
No, my fault. Thank you.
So, my Lords, after setting out the immigration rules, the decision summarises the initial period of lawful residence. The paragraph beginning, given the above, it is accepted you arrived in the UK on 24th February 2010. The next paragraph refers to two applications for an EA residence card which were rejected, but at a time when the appellant had leave. But then on the 6th of July, the second sentence in that paragraph, reference is made to the relevant application for this appeal, an application in time for leave to remain on the basis of family and private life. That was rejected per the letter on the 22nd of January 2018 because he failed to pay the immigration health surcharge. And further on in that paragraph, it is said by the decision maker, where an attempted application is made that is later rejected, that application is not subject to the provision of Section 3C, therefore your valid leave to remain expired on the 14th of July 2017. It is now accepted that that part of the letter is wrong and that in fact Section 3C was engaged. That part of the decision of the Court of Appeal in Afzal is accepted between the parties and not under appeal here. And therefore Section 3C was engaged. It's just a question of when that leave came to an end. The next paragraph then talks about the out-of-time application submitted on the 2nd of February, states that that period cannot be counted. The next paragraph then clarifies that paragraph 39E does apply, and it means that the appellant would not be considered as an overstayer for the purposes of the immigration rules, meets the requirements in paragraph 276B5, but that the Secretary of State's own guidance states that Section 3C is not engaged and that he stopped being continuously resident with respect to 276B1A on the 14th of July 2017, and that must be continuously lawfully resident because the continuity of residence is clearly not interrupted. It's the lawful residence that's being referred to there. And as this date is fewer than 10 years after her arrival, her application must be refused. And then you have the conclusion at the bottom of the page. Consequently, it is accepted that you have accrued a total of 7 years, 5 months continuous lawful residence in the UK. And that the application, therefore, must be refused because it does not meet the requirements of 276B1A. If I could then take my lords to the relevant statutory provisions and the subordinate legislation.
And just before we do, from what you say, to understand that the Secretary of State's position is effectively that that now has to be read as if 14th July were actually 22nd November as the Court of Appeal held.
My Lord, yes.
So the period, instead of being 7 years, 5 months, will be 7 years, whatever it is, 9 months.
Yes. And my Lord, there's nothing in this that tells us whether the Secretary of State's position was that that means you cannot succeed and the clock has started again. That would seem to be the position. The refusal is on the basis that you've got 7 years and 5 months worth of lawful residence. It doesn't tell us about the lawful residence subsequent to the grant of leave in 2019. It doesn't mention any effect of the disregard provisions in 276B5.
But on that, I thought the Court of Appeal was clear that on their interpretation of disregard, the bookended period doesn't positively count towards the 10 years, but it doesn't break it either.
My Lord, yes.
So you keep accruing time, and indeed the Court of Appeal says it may well be that either now or soon an application could be made which would satisfy the 10-year.
My Lord, yes.
And just to be clear, so I can be correct if I'm wrong in my understanding, I didn't understand the Secretary of State to challenge any of that.
No, the Secretary of State does not challenge that before this court. But in terms of the decision made in 2020, it's not clear whether the decision maker understood that it would appear, and that's material because the decision under challenge was a decision to refuse to grant indefinite leave, and there has been some success already on the part of the appellant because, pursuant to the Court of Appeal's judgment in Afzal, the Court of Appeal found that you are, at the date of that judgment, now entitled to indefinite leave because the period in between falls to be disregarded. There's nothing in the decision that suggests that the decision maker was aware of that. And that is relevant for the purposes of disposal, but it is also relevant in terms of understanding how the case has developed and what the understanding of the caseworker was and where we are now. But my submission on the letter is that there is nothing that suggests that the decision maker understood that the period in between fell to be disregarded. Although the decision maker does accept in the penultimate paragraph on that page that 39E does apply, accepts that the application comes within 276B5, there is nothing that suggests that the decision maker is then going on to apply the bookended reasoning to the application.
I suppose the same point you've made already applies to that penultimate paragraph. You stop being continuously resident. What they mean is continuously
lawfully resident, my lord, yes.
For the purposes of 278B1.
And one would expect that if the decision maker had understood the way in which the rule operated, that it would have been said that you've accrued whatever the amount was when you add the period after the grant of leave in 2019. So this is a decision in March 2020, about a year after the grant of leave in February 2019. So one would have expected that the last paragraph would say, consequently, it is accepted that you have accrued a total of 8 years and 6 months, or something like that, so that the appellant knows when he is going to be eligible for ILR and that he will be eligible in due course. Based on the understanding of the letter that my submission is that this letter suggests to the appellant that you haven't met it because there's a break and you must now accrue a further 10-year period in order to satisfy the long residence provisions.
So, I mean, the decision maker for this letter will be looking at presumably the date of the application and then working out whether there's 10 years up to that date.
My lord, yes.
And can you just help me? The date of the application was what again?
My lord, the date of decision is the 11th of March 2020.
The date of application.
The date of application, the 2nd of February, 2nd of February 2020. So just a month earlier.
And what do you say the correct figure should have been instead of the 7 years, 5 months?
My lord, if we're adopting the reasoning in Afzal, then it would have been 7 years and, July, August, September, October, November. You've got another 4 months, so 7 years and 9 months, plus the 2nd of February 2018 to, if we're just taking the date of application, to February 2020, that's another, apologies, it's September 2019 when he was granted, February 2020 when he applied, so there's a further October, November, December, January, February, about 6 months of leave. So we're looking at 7 years, 8 years and 1 month if we take the reasoning of the letter, because the letter doesn't add the extra period that Afzal added. So if we take that reasoning, it would have been a further 6 months added if the decision maker had been alive to the fact that the lawful period had not been broken, it had just been sort of paused with a period in between that had been ignored.
Thank you.
If I could take my lords then to section 3C, which is at page 712 of the bundle. I'm sure my lords will be very familiar with this provision.
I wouldn't make that assumption. Some people are veterans of immigration law, but others less so.
My lord, then I'll take you through the section. It is, of course, now accepted that the section applied. And so section 3C, 1A, a person who has limited leave applies for variation. B, the application for variation is made before the leave expires. And C, the leave expires without the application for variation having been decided. So all three of those requirements were satisfied in Afzal's case. 3C2.
Sorry, I thought there was an issue that they weren't satisfied because although he had made an application for variation before the leave expired, that was rejected and the relevant application was made later.
My Lord, no, the Afzal's judgment accepts, in accordance with the decision of this court in Ehsan's case, in Mirza, that the application, because it was accompanied by a fee waiver, was valid at the time and became invalid at some point thereafter. So when the application was made, prior to the expiry of leave, the application at that time met all the requirements that it needed to meet.
So that's the application on what date?
What was the date of that?
July 2017. 6th of July.
6th of July 2017, I'm told, my Lord.
So 6th July 2017, yes.
The application is accompanied by a fee waiver.
Yes.
If it had not been accompanied by a fee waiver and the fee had not been paid, then per the decisions in Mirza, the application would have been invalid ab initio. But because there was a fee waiver application,
yes,
Section 3C was engaged.
But that was rejected 3 months later. Was it the application for fee waiver?
The application for fee waiver was rejected in October. And then the appellant was given an opportunity to pay the immigration fee and the immigration health surcharge. There's a bit of a dispute as to whether the letters informing him of the requirement to pay the fees and the time limit that he had were received or not. I'll come on to that later.
Right. But I mean, my notes, trying to get the chronology right, suggest that on the 18th of October 2017, the Secretary of State rejects the fee waiver,
yes,
and requires the fee and the IHS charge.
My Lord, yes. Perhaps we can go to that letter.
All right. And yes, all right.
I think it's 298.
I'm grateful, my Lord. My Lords can see at 298 the notification and the reasons why the application is held to be invalid at that time is that the appellant does not qualify for a fee waiver.
There's a follow-up letter of the same.
My Lord, yes, there is a follow-up letter, but my Lord will see that having said that the application is invalid at 298, the letter then goes on at 300 to 302 to explain why the fee waiver application has not been accepted.
Does that letter demand payment of the fees within 10 working days?
My Lord, that is covered by the last paragraph of the letter at page 302. Your application for a fee waiver has been rejected. You have not made a valid application as you are required to pay the application fee. Please refer to the enclosed letter which tells you what you need to do in order to make your application valid.
Where's the enclosed letter?
My Lord, that's the letter that has been sent yesterday afternoon, which wasn't enclosed in the papers, and it wasn't noticed because before the Court of Appeal.
Yeah, we have just received it.
I'm grateful. Perhaps we can look at that letter then.
Right. Okay, so that is saying you've got to sort things out within 10 days, and it is referring to the IHS fee.
My Lord, yes. So the language of this letter is slightly different to the language of the other letter. The other letter says that your application is not valid. This one says your application is not yet valid, and giving an opportunity to correct the missing information. That is also what we say a difficulty with the drafting of this letter. I don't think it impacts upon the questions of legality. It is a factor to take into account, because per the Court of Appeal's decision in Afzal, this letter is crucial. This letter tells the appellant when your leave will now expire, because your application is rejected as invalid automatically 10 working days from the date of the letter. And my lords will see in bold on the first page of the letter, and what the letter actually says is you must provide all of the missing information within 10 working days from the date of this letter. Otherwise, your application will be rejected as invalid. So it's not referring to payment of the fees within 10 working days, although I think it's clear from the rest of the letter that is what is being asked for. But nevertheless, it isn't accurately telling the applicant what needs to be done within 10 working days, and many applicants represent themselves. It is important that the letter communicates that.
I don't understand you to be suggesting that there was any actual misleading here. It was understood from this letter what was required.
I'll come on to that, my lord, because the appellant's position is that this letter was not received. The subsequent letter was not received, and I'll come on to what happens next, which in my submission...
So you're saying this letter also was not received?
My lord, yes. Those are our instructions. The instructions, as I understand it from the Secretary of State, are that it is believed that this letter was sent with the other letter, but I don't think there's any confirmation of that.
Well, the other letter did refer to an enclosed letter.
It did refer to it, but in the acknowledgement of service and summary defence, where that letter was served during the judicial review proceedings, this letter wasn't included. Right. And this letter only came up when we asked for it, because we could see that there was something missing from the documentation. It's important in one sense also, because in Afzal, the Court of Appeal says that the application is rejected automatically as invalid 10 working days from the discretionary letter per paragraph 6 of the 2015 order. That would mean that the application falls to be rejected invalid by operation of law 10 working days from the date of this letter, rather than the second letter, which again raises the question why the second letter was sent.
And as I understand that your client accepts that he received the first of the letters.
Yes.
Of the 18th of October. I'm not sure we are going to want to get to be drawn into a factual dispute, but about receipt of this letter. But was any letter sent by your client asking for the letter which was said to be enclosed in?
My lord, no. But there was a letter, and perhaps I should take my lord to that so that we have a complete picture of the factual case. The letter, if I could take you to 303, which is the November 2017 letter, so we can just see that. And that is a slightly different letter, because it's now only the immigration health surcharge that's outstanding.
Well, before doing that, if you can go back to 302, the last paragraph. If that was the only letter received, and of course it's a factual question, I'm not quite certain how why it's relevant to this, in this court. But the last paragraph says you're required to pay the application fee. This is exactly what he did.
My lord, yes, that's the other point, that if that letter had not been received, and we say that what actually happened is consistent with what he is saying, he might have understood that all that needed to be paid was the application fee. The application fee was in fact paid. He didn't then receive the November letter. He receives the rejection notice on the 22nd of January, and that is at 305. so that's sent out on the 22nd of January telling the appellant that his application has been rejected and why it has been rejected. One would expect that it would have been received by his solicitors a couple of days thereafter. And then you have at 2:55 a letter sent very soon thereafter, within about 8 days, from his solicitors, enclosing the completed application form and both fees.
Sorry, just while we're going through this, I mean, the 8th November letter, page 303, that's also addressed to his solicitors.
My Lord, yes.
So,
And the evidence that he didn't receive it, does that come from the solicitors or does it come?
My Lord, it does. I'll take you to that.
Okay.
So the letter from the solicitors at 2:55. And my Lords will see that this issue is addressed in the 3rd paragraph.
But do I understand that despite this, there was never in fact a challenge to the rejection of the application of the 6th of July?
My Lord, that's right. And the reason for that, my Lord, I think that is explained, my Lord, if one goes to the document immediately before that letter at 2:53 to 2:54, that is a witness statement from the caseworker at the solicitors that was submitted with the judicial review claim. And at paragraphs 4 and 5, that explains the evidence from the solicitors and the reason why he decided to make a new application, because of the way the rules are structured, rather than the expensive and uncertain procedure of challenging the decision by way of a judicial review claim.
And would you please assist me then as to the import, the relevance of the points you've been making as to whether these documents were enclosed or not?
Well, my Lord, based on the reasoning in Afzal, the application is only invalidated automatically if a letter is sent out. And if that letter has been sent out, and we don't have any evidence that the letters were sent, of course we know that the rejection of the fee waiver was received. The suggestion is that the November letter was not received. We don't know if it was sent. We have the letter with the date, but we don't know that it was sent. There's no evidence from the Secretary of State in relation to that, either a file note or a witness statement from anyone that confirms that it was sent and where it was sent. And we also don't have any confirmation that the enclosure with the October letter was sent. So if that letter wasn't sent, then the automatic provision that the Court of Appeal relied upon doesn't bite, because it only bites if a letter is sent.
But if we can't resolve that particular issue and you didn't challenge it, as you accept, I think, you didn't challenge the rejection of the application, is it too late now to do that before this court, to raise these points before us?
My Lord, the appellant is not challenging the rejection because the rejection is correct. He didn't pay the IHS. What he is challenging is the date on which his application became invalid. And that's an issue that has only arisen in the course of his application for indefinite leave to remain. So the letter of the 22nd of October, which says that he has failed to pay the immigration health surcharge, is accurate. He didn't pay it. His complaint was, you should have reminded me. But in any event, he paid it. I'm sorry, my Lord.
Where are these arguments in the written case?
My Lord, the written case before the Supreme Court.
Yes.
My Lord, it is the fact of...
I certainly picked up the fact of the second of those letters not being received.
Yes.
Certainly, but I wanted to know where the consequence of that was set out in the written case.
My Lords, at paragraph 22 at 659, reference is made to the fact that this matter was not considered by the Court of Appeal and the uncertainty that it results in.
Right, but I mean, that's just referring to the letter of the 8th of November.
Yes.
You've been telling us also about the letter of the 18th of October. I mean, I've gone back to the agreed statement of facts, and this is paragraph 4, which is, I think, page 58. And it says positively, on the 18th of October 2017, the respondent rejected the appellant's application for fee waiver. At the same time, the respondent asked the appellant to pay the application fee and the immigration health surcharge. So that's an agreed fact.
My Lord is right. The fact that that letter was not enclosed in the documents has only come to light in the last few days.
Yes, but it's an agreed fact that the request was made, and it's only in that letter, the second of the 18th of October letters, that request is made. So it seems to be an agreed fact that that letter was both sent and received.
My Lord, that is what the agreed statement of facts says.
Yeah.
But my Lord,
just to add, the point of us having an agreed statement of facts and issues is that we don't get drawn into debates about the underlying facts.
my Lord, I apologise. It's something that just come to our attention. We think it is important and ought to be drawn to the court's attention,
right,
because that letter is crucial. And as my Lord has pointed out, the letter that we know was received only refers to payment of the application fee.
Yeah, but, well,
and my Lord,
to repeat the point, paragraph 4 makes it clear that there was an additional request for the IHS fee as well.
I understand, my Lord. I take your point. The absence of the letter came to light a few days ago. We requested confirmation of it from the defendant, from the respondent.
But I just thought it would be obvious to a person who hadn't been requested to pay the IHS that he would know that. So the fact that it's only become apparent to the legal advisors recently.
My Lord, yes. I think because there had been a focus on the November letter not having been received, the significance of the first letter not having been received perhaps escaped us. It is also the case that before the Court of Appeal, this issue was not ventilated. So the parties' positions were that Section 3 is engaged, and the upper tribunal judge had found that it was engaged and that it came to an end on the 22nd of January. And the respondent's position was that Section 3 simply wasn't engaged. So the middle ground was not discussed in the skeletons advanced by the parties. It wasn't discussed at the hearing. That's something I think that's said in our application for permission to appeal. So these matters have not been fully ventilated up until now, but I do take my Lord's point. All I can say is that this is the state of the evidence, and it might be that my Lords decide that the October letter is taken to have been received, and whatever the consequences of that are for the construction, and on the facts of this case in particular. But, my Lord, this is the state of the evidence, and I think what it also draws...
we can't entertain... this court can't entertain arguments which turn on disputed questions of fact, because we're not in a position to resolve factual disputes. And I appreciate it may be unfortunate if an issue of fact only emerges at the 11th hour, but the fact is, if it only emerges the day before or a couple of days before a hearing in the Supreme Court, I'm afraid it's too late, because the time for factual issues to be decided is long past.
My Lord, I simply draw it to your attention so that you're aware of it. It's not something that forms a foundation of the appellant's case at all, but it's something that the appellant feels is important to draw attention to. But what it also does do is draw into sharp focus the problem with construing the regulation, the order, in this way, because the manner in which the letter is sent, reminding an appellant to pay the immigration health surcharge, is not regulated. If I could take my Lords to the order, which is at
730.
730. I'm grateful, my Lord. And it's subsection 1 that is a relevant subsection. And my Lords will see from subsection 1A that all that the order says is that the Secretary of State may request that the applicant pays the outstanding charge. There is nothing that then regulates how that request is made, except for B, subsection 2, saying that the request can be made in writing, by telephone, or in person. But there's no mechanism of recording that, no mechanism for deemed receipt of a letter.
Well, there's no necessity for a request at all. Under A,
My Lord, that's right.
may request, but B must pay, regardless of whether a request has been made or not.
That is right, my Lord. And the appellant does not dispute the fact that the IHS must be paid. The question is that if it is not paid, on what date does the application become invalid, which is crucial for many applicants. And my Lord will also note that at paragraph 6.1, the provision envisages that the Secretary of State might well have already granted the application, which is again at odds with the language of the order at paragraphs 3 and 5, which says that the immigration health surcharge must be paid and must be paid at the time of application.
But doesn't 6.1b start the clock from the date upon which the letter is sent?
My Lord, yes. It starts the clock on the date that the letter is sent, but what one has, and I'll take my Lords to Appendix S8, which reflects other regulations made in the immigration system. Usually, when one is sending a letter out that has this sort of consequence, with rights being affected, there is a detailed mechanism for the letter to be sent, rules about how it is sent, where it is sent to, deemed receipt of it, and also a mechanism for a person to say, well, actually, I didn't receive it, and therefore deemed receipt doesn't take effect.
But if none of those rules apply in this type of case, and I don't think you're saying that they do, all we're left with is 6.1b2, isn't it? Sent in writing. And
my Lord, yes, and that's why we say one of our submissions is that that cannot have been the intention, and if that is the intention and that is the effect, then it ought not to be given effect, it ought to be read down pursuant to the principles in Anna Frigeva of legality and fairness. But
all right, I don't want to leap ahead.
So, my Lord, just whilst we're looking at this order, as I've already said, the language in paragraph 3 and paragraph 5 is also the language of must. So an applicant must pay the charge, must pay it at a certain time. Paragraph 6 also uses the language of must, but also envisages that despite the applicant having to pay it and having to pay it at a certain time, the application might already have been granted. And then if one looks at paragraph 8 on 732, one can see that the Secretary of State has a wide discretion to reduce, waive, or refund all or part of a charge.
And how is that relevant?
My Lord, we say it is relevant because the language of must that is used throughout the order must be subject to the overall discretion to waive it.
Right,
So although
that hasn't been exercised in this case, so we're just left with the language of the order saying must, aren't we?
that's right, but the fact that it could be exercised is relevant to construing paragraph 6. Because there is a discretion. I'll come on to the language of the Secretary of State's letter and also the language of the Secretary of State's own guidance that applies to invalidation of applications.
I thought the letter, I'm sorry for jumping ahead, had already exercised discretion. So the discretion in paragraph 8 had already been exercised against the applicant.
My Lord, yes. It had been exercised against the applicant, but I think I'm correct that the letter, which is the way in which these rejection letters are usually drafted, also gave an opportunity for the applicant to send in further evidence.
Can I ask, is there a legislative basis for the waiver?
I think, my Lord, there is certainly a basis in the immigration rules for the waiver.
Well, what's going through my mind is if the order, which is legislation, says must pay, the immigration rules couldn't override that.
My Lord, the way that I would put it is, first of all, the discretion in Article 8 clearly applies and permits the Secretary of State, pursuant to the order, to reduce, waive, or refund all or part of a charge.
Oh, I see. Yes, that is the basis. It's Article 8. The Secretary of State has discretion to reduce, waive, or refund. No.
All or part of the immigration health surcharge, yes. My Lord, it's also relevant at this point to look at Regulation 7, because that is the provision that the Court of Appeal referred to. It didn't refer to paragraph 8. Paragraph 7 talks about exemptions.
You mean Article 7 of the order?
That's right.
Yeah.
And the exemptions are all set out exhaustively at Schedule 2, and they don't include a fee waiver, and therefore...
Well, they wouldn't, would they? I mean, if you're exempt from paying the fee, you don't... The concept
That's
of
right.
waiver.
That's right. And therefore it's the discretion that bites when one is applying for a fee waiver. And in the context of that overarching discretion, which is not limited at all, it's a discretion that seems to apply throughout the life of an application, including in relation to a refund. If one then looks at Article 6, there is a discretion for the Secretary of State to send a letter reminding a person in the context of her overarching discretion to reduce, waive, or refund any or all of the charge. So she can exercise that discretion, but per the
but she
instruction...
hasn't here. Forgive me, I'm just trying to see what the relevance of this is to your argument. I didn't understand there was any suggestion that the Secretary of State had waived the IHS fee in this case.
No, there isn't. I'm just saying that these provisions are relevant to construing Article 6, which is the basis upon which the Court of Appeal said that the application is invalidated automatically 10 working days from the date that the letter is sent. So the way that would work is that the Secretary of State has a discretion to send a reminder, but once that discretion has been exercised to send a reminder, the application is refused after 10 working days without any further decision by the Secretary of State. That discretion at Article 8 is then taken away from her after she exercises the discretion to send a reminder, which we say is a very odd outcome in the context of the way that this order is drafted, and also in the overall context of the way that the immigration system works.
Well, sorry, just on that, I'm not sure that's right, is it? I mean, Article 8 of the order seems to be entirely general.
Yes, and therefore one would expect that up until the last moment, the Secretary of State, even if she sends out a reminder, can still exercise discretion and say, well, I'll waive the fee.
Well, even if the application is refused, she can
That's right.
waive or refund.
That's right. And so the point is that if the judgment in Afzal is right, that once this letter is sent out, we're on a course, which means that 10 working days from the date that the letter is sent, the application is rejected as invalid. The discretion to waive is taken away. And we say that that would require clear language because of the nature of the discretion granted in the order. It's a very wide discretion, and that is certainly, and I'll take
but
my Lord.
Isn't the structure this, that it is clear from Article 6 that unless the Secretary of State positively exercises such discretion as they have under Article 8, there will be an automatic invalidation of the application after 10 days.
Well, we say, if one looks at the language, yes, the order says in...
And so I come back to the point,
C.
there's been no suggestion that the Secretary of State has positively exercised that discretion.
My Lord, the appellant is not saying that there is any problem with the Secretary of State's exercise of discretion. These submissions are in relation to the construction, so we're not saying that anything went wrong in the appellant's case.
Forgive me. I'm putting to you a point on construction.
Yes.
That isn't it clear from the structure of Article 6, read with Article 8, that Article 6 governs unless and causes the automatic invalidation of an application after 10 days of the request being sent, unless the Secretary of State positively exercises the discretion under Article 8
Yes.
to waive that.
Yes.
In our case, Article 6 applies because the letter of the 18th of October was sent. There is no suggestion, I think you have confirmed, that the Secretary of State exercised her discretion under Article 8 to waive that. And so aren't we left then with the consequence specified in Article 6, that after 10 days the application is automatically treated as being rejected?
My Lord, that isn't what the regulation says. That's not what the order says. So what the order says, and it's important to look at the exact word used, because that phraseology is the same phraseology that's used in the biometrics regulations. And what it says, if one looks at Article 6, C, 6.1c, and it's subparagraph 2, subparagraph, if the outstanding charge is not paid within the time period, the application for leave to remain must be treated as invalid by the Secretary of State. So it doesn't say that the application is invalid or will be invalid or is invalidated automatically. The language used is that it must be treated as invalid by the Secretary of State. So that's an instruction to the Secretary of State. It's the Secretary of State that does the treating. And we would say, although we accept that it is highly unlikely that the Secretary of State would ever do this, but Article 8 still leaves open the possibility that despite that instruction, the Secretary of State exercises discretion and grants the application, or waives the IHS and refuses the application. We say that that is possible, but whether it is possible or not, in one sense, is irrelevant for the purposes of the construction, because the language is that the application must be treated as invalid by the Secretary of State. And perhaps this is a good time to go to the biometrics regulation so we can contrast the language. That was sent to...
Can I just be clear? All this is going to the question as to what date does the application become invalid.
My Lord, yes.
The case against you is that it's on the 22nd of November 2017 for the reasons effectively that Lord Sales has been putting. What is your precise answer to the date at which the application becomes invalid?
My Lord, we say that it is the date on which the Secretary of State treated it as invalid,
Which was
which
when?
is the 22nd of January 2018, when she sent the notice out.
Thank you.
And that was the case addressed by the Court of Appeal.
That was the case addressed... Well, the Court of Appeal did not hear argument on whether the date was November 2017 or January 2018, because the submissions of the parties before the Court of Appeal were either the 22nd of January 2018 or Section 3C simply wasn't engaged. And the decision of the upper tribunal, Judge Stephen Smith, was that Section 3 was engaged and the date on which leave expired was the 22nd of January. So those were the parameters within which the parties were presenting their cases before the Court of Appeal. But Sir Patrick Elias decided that neither position was correct and reached this construction on the basis of the language of the order. If I could take my lords then to the biometrics regulations, and it's Regulation 23 that is relevant.
I'm sorry, just before we go there. I mean, we're looking at a piece of legislation in Article 6, and it tells us that if the outstanding charge isn't paid within the time period, in other words, the 10 working days, the application for leave to remain must be treated as invalid by the Secretary of State. Now, you seem to be, on what basis do you say the Secretary of State could lawfully treat the application for leave to remain as invalid only with effect from a date some months after the period for payment had expired?
My Lord, there is nothing in Regulation 6 that governs when the application must be treated as invalid. It just says that it must be after 10 working days.
So he must, or she must, as at such date as she thinks fit, treat it as invalid.
Well, it might be, my Lord, that if one is working on the basis that it is the Secretary of State that does the invalidation on instruction from the order, and there is no discretion to depart from that, if we're working on that assumption, it is still the Secretary of State that does the invalidation. And when she does it as a matter for her, one would expect that she would do it fairly soon. And how she does it is important because that's governed by the immigration rules, Appendix SN.
So you say, so must be treated is really read as must invalidate.
Must invalidate,
and
must treat it as invalid. It doesn't say must invalidate, it says must treat it as invalid, which is...
But you're saying that it can only be treated as invalid by taking a positive step of doing something which makes it invalid.
And there is a mechanism for that, which is set out in the immigration rules and in the Secretary of State's own policy guidance. So it's the Secretary...
I'm so sorry, I didn't mean to cut across you.
No, it's the Secretary of State that does the treating. So the instructions from the order, but that must be carried out by the Secretary of State. The order doesn't do it.
And effectively, cutting to the chase, as it were, the Secretary of State doesn't treat it as invalid until she notifies the...
My Lord, yes. And that's a fundamental principle.
Yeah.
And my Lord, there is nothing, there is no sort of magic or smoke and mirrors in this for any applicant. It's just a question of notification and the date on which a certain consequence ensues. There is no advantage to any applicant of having it treated as invalid later as opposed to by the order, except that they get fair notice of it and can act, and they're protected. And it's not just, of course, the applicant that is protected. It's all, and this has been discussed in Mirza at length and discussed by the Court of Appeal in Afzal, it's third parties affected by the status of the applicant that are also protected. So, my Lord, we would...
But I mean, even on your interpretation, that's not talking about issues of notice to the applicant. It's just some positive act by the Secretary of State.
But the notice issue comes in because that is the mechanism that the immigration rules provides in Appendix SN, which I will take my Lords to. I wanted to take my Lords to the biometrics regulations to compare the language, and then I will take my Lords to Appendix SN and the policy guidance.
Yep.
So the biometrics regulations, my Lord, it's Regulation 23, and that's at page 29 of the PDF.
Now, this is a separate PDF, isn't it?
My Lord, yes.
Yes, I think I've got that. That's 33 pages setting out the regulations. Right, and which page did we go to?
It's 29, my lord, of the PDF. And my lords will see that it's 23.2 and 23.3 that govern the consequences of a failure to comply with the biometrics regulations as far as invalidation of an application is concerned. And the language is the same. 23.2b, the option is to treat the person's application for leave to remain as invalid. And at 23.3, B again, 23.3b, must treat the person's application for leave to remain as invalid. So whereas 23.2 contains a discretion, so it's a power to treat an application as invalid, but the application does not necessarily have to be treated as invalid. 23.3 is an instruction in identical terms in all material respects to the order, must treat the person's application for leave to remain as invalid. But in both cases, if you are doing the treating, the mechanism is the same. It's the Secretary of State that does the treating. So how that is done should be the same in both cases. And we know from the Supreme Court's decision in Mirza that for Ehsan, the appellant that had the biometrics issue, the court found that leave came to an end on the date when that was done by the Secretary of State. A decision was sent invalidating the application. And it is, if one looks at the structure of Regulation 23, 23.2 does not apply to all applications. It is subject to paragraphs 3 and 4. And paragraph 3 specifies that where a person is required to apply for a biometric immigration document under Regulation 3.2a or b, or as a dependent of such a person, then the consequences in Regulation 23.3 apply, which is you must treat the person's application as invalid. And if one goes back to Regulation 3, which is at PDF 5 of the document, my lords will see that 2A and B is probably the most commonly encountered type of application, an application for indefinite leave or an application for further leave where your leave is going to extend beyond 6 months. So if one contrasts it with the situation of Afzal, if he had been in breach of the requirement to provide biometrics, his application would have been governed by Regulation 23.3, and therefore, again, the Secretary of State would have been required to treat the application as invalid. But there's no date given. It just says you must do that if he doesn't comply. There's no mechanism for reminders or anything, although the policy and the rules might well contain such mechanisms. But the regulations themselves simply say that if biometrics is not satisfied, you must treat the application as invalid. And we know from the decision in Mirza that the way that that was done was a notice.
And your essential case is that the facts of this case are on a par with the biometric situation,
my Lord, yes.
and therefore Afzal tells us what we should do. Mirza tells us what we should do.
My Lord, yes. If there is a distinction, the distinction drawn by the Court of Appeal is that in Ehsan's case, the third appellant in the Mirza appeal, there was a discretion because it was 23.2 that applied. But that really is irrelevant because the instruction is still the same, the mechanism is still the same. the Secretary of State may treat the application as invalid. That is what she did, and the effective date of treating the application as invalid was the date of the notification. And when one looks at that paragraph of the judgment of the Supreme Court, and I'll take my lords to it later, one can see that part of the judgment is actually directed towards, the discretion part is directed towards another issue, which is whether there was retrospective invalidation. And we say that it doesn't matter whether the instruction is that you must or you may. The mechanism is the same, and that mechanism must be the same whether it's biometrics or immigration health surcharge. It makes sense.
Doesn't it make quite a big difference whether the Secretary of State has a discretion to do something or is required to do something? It makes legislation, because if the Secretary of State has a discretion to do something, you do need some positive act by the Secretary of State to exercise that discretion. But if the Secretary of State doesn't have a discretion and the law simply says the Secretary of State is not lawfully permitted to treat the matter as valid, there's no action required by the Secretary of State.
My Lord, that's our point, that in both cases, whether there is discretion or not, the language is the same and therefore action is required. But the order and the regulations dictate what the action must be. And of course the order and the regulations are given to the Secretary of State by the Secretary of State. She has made the regulations, she has made the order, she's set up the system, and so it's the way in which she has said that she will exercise her powers, and if you don't comply, your application will be rejected as invalid. But that rejection process and the mechanism must still come from the Secretary of State. And the appellant has no complaint about that. That is the way it is. The only issue for the court is when that takes effect. And the appellant's case is that it must be when a notice is sent. Not only is that consistent with the language of the order and the regulations, it's consistent with the mechanism provided for in the immigration rules. It's consistent with the Secretary of State's policy and practice, and it's also consistent with the fundamental requirements set out in Anifrageva of notice and the rule of law and fairness.
Well, sorry, if I may say so, it seems somewhat ambiguous to say it's when notice is sent. I mean, are you saying, and then to talk about Anifrageva, are you saying when notice is sent and received?
My Lord, yes, because that is the mechanism. And that mechanism already set up. So it's not that the appellant is saying this is how it should be sent. And perhaps, my Lord, I'll take you to Appendix SN, so one can see how the Secretary of State herself has set up the mechanism. Appendix SN begins at 796. And my Lords can see, I don't want to unnecessarily read material out, but my Lords will see from the 3 pages exactly how the mechanism has been set up. And it is also pertinent to sort of take into account that this also applies to administrative review decisions, and therefore there is already an interaction with Section 3C, because Section 3C subsection 7 makes reference to leave under the section coming to an end when the mechanism in the immigration rules is followed with respect to administrative review decisions.
Does Appendix SN apply to whatever happens under the order that we've been looking at, the IHS order?
My Lord, yes. So if one looks at SN 1.2, a notice in writing that an application for entry clearance, leave to enter or leave to remain in the United Kingdom is invalid.
But that rule seems to be predicated on some aspect of an order or regulation saying a notice must be given in writing, and then this says what happens where that says.
Well, my Lord,
where that applies, but in Article 6, that's not the formula that's used.
I think that it was not, it was accepted by Sir Patrick Elias at the Court of Appeal that if the order didn't automatically provide for invalidation, then notice of invalidity is something, well, invalidation is something that is governed by Section 4 of the 1971 Act and requires a notice in writing.
This is an appendix to the immigration rules. If you look at the introduction, the very beginning of the document, it tells us that notices of appealable immigration decisions are served under the regulations mentioned. Notices of non-appealable immigration decisions which grant or refuse leave to remain, etc., are served under an order from 2000. Then notices falling within paragraph SN 1.2 of this appendix to the immigration rules are to be served in accordance with this appendix. Now, which category are we dealing with in relation to Article 6 of the order we've been looking at?
My Lord, I apologise. I should have taken you to 755 first.
Right.
And it's 34B, subsection 5.
And what are we looking at here?
The immigration rules, my Lord.
Right. So it's maybe helpful if we go back to 753 just to see paragraph 34, because that seems to be what this is about. And I think one can see 34, paragraph 4, refers to the requirement to pay the IHS.
Yes, my Lord. And then, my Lord, will see that there is discretion within the rules at 34B1, there is reference to the discretion to send a reminder. At 2, we have the provision that is consistent with Article 6 of the order. And then at 3, subject to the discretion, the application is invalid.
What page?
My Lord, 755.
Okay.
And my Lord, at 4, the rules themselves suggest that even where an applicant is not paid after 10 working days, the Secretary of State may exercise discretion to treat the application as valid. It's only 3, 5 and 10 which cannot be overridden. 3 is the application fee, 5 is proof of identity, and 10 is biometrics.
But if the order has taken away any discretion for the Secretary of State to treat an application as valid where the IHS fee has not been paid, I wouldn't have thought that a statement in the immigration rules can give the Secretary of State discretion.
My Lord, no, but that is, the appellant's case is that the order doesn't do that, and the appellant's case is that one must construe the order in the overall context of the system set up by the Secretary of State herself. And when one looks at the way the rules are structured, when one looks at the Secretary of State's own policy guidance, one can see, quite understandably, because that is the way the entirety of the Secretary of State's immigration functions are exercised, by notice in writing, ensuring that a person has proper notice of a decision that affects his or her rights. So a situation such as this, where leave ends on the basis of the operation of law that can come about without a notice that is regulated, is an exception. And one does have, if one looks at Section 3C, one does have circumstances where the passage of time results in leave coming to an end. But that passage of time is followed by a notice that is regulated.
So the important provision in 34B, I think, for your argument, is paragraph 5.
My Lord, yes, for Appendix SN, but also the rest of the structure of B, we submit is consistent with the appellant's case on construction of the order.
Well, there's no discretion where the fee hasn't been paid. That's paragraph 40.
No, but this is an IHS case, the immigration health surcharge. So
Well, there is a discretion in relation.
There is a discretion in relation to the immigration health surcharge, my Lord, at 34B, subparagraph 4.
It's 34.4 and not 34.3. Yeah. So
I see. So the IHS isn't a fee within the meaning of paragraph.
No, the application fee is different,
right. And
the IHS is an immigration health surcharge, which is a payment, a fee, but it's described differently.
Yeah. But in any, well, the rules can't possibly confer a discretion which would be contrary to the legislation.
It would mean that the Secretary of State has misunderstood her own order. And we say that that is not the case. We say that they are all in line with each other. It's just that the Court of Appeal misconstrued the effect of Article 6 because it failed to appreciate that the order was giving an instruction to the Secretary of State, and it also failed to appreciate that that instruction was subject to the overarching discretion at Article 8.
Well, that's the point, is it? That the order we're being required to construe has got this apparent conflict between the duty to treat as invalid, subject to Article 8 discretion.
My Lord...
And if I might just... And you're saying that that is mirrored by the immigration rules, 34B, where you've got the similar sort of tension.
My Lord, that is one of our submissions.
Right.
That there is that tension, and that is why it is important to look at the language of the other provisions and the way the order works overall to understand how the use must has been used.
Yeah.
It has been used to say that you should do it, really, but there is always discretion. But the other part of it is that even if one doesn't look at the discretion and one accepts that the 10 working days means that the application must now be invalid, the language of the order requires the Secretary of State to do the treating. The order doesn't do it. The mechanism is that you must now do that, and now you follow your procedures pursuant to the rules and your own policy to do the treating of the application as invalid. A notice is sent out, the applicant finds out, and as happened here, the applicant realises that his application has been treated as invalid. He must do something very quickly. He does it very quickly. His application is accepted and his leave is granted.
So if you're saying these rules are, as I understand you to be saying, an aid to the interpretation of the order, can you tell us the date of this part of the rules?
My Lord, these are the rules that were enforced at the date of the relevant decisions in Afzal. I can...
You're framing them in aid as an aid to interpretation of, I think it's a 2015 order.
My Lord, I don't think, my Lord is right, I don't think that we have the version of the rules that were in force at that date, at the date on which the order was brought into force. But my Lord, we can certainly provide that to the court. There is.
It's only if you want it for your argument, but I mean, insofar as you're trying to rely on this version of the rules as an aid to interpretation of an earlier order, it doesn't seem to me that these rules would be a valid interpretation of the...
My Lord, I take my Lord's point, and we will find that my understanding is that there is no difference in the mechanism. It's the same, but we've provided the rules as at the date of the relevant decisions. But my Lord is right, we ought to provide the rules as at the date on which the order came into force.
Only if you're trying to base an argument on it.
I mean, the crux of your argument is that the notice isn't simply informative. The notice is constitutive of the invalidity of the application.
My Lord, yes. It is the manner in which the power is exercised. It's not a notification of the exercise of power. I think that's the extract that was quoted in the Court of Appeal. Can I then take my Lords to the Secretary of State's guidance? And that is a separate document. There were two versions of the guidance sent out. Version 1 is the version that was applicable on the date of the decision in Afzal's case. My Lord, it's page 10.
I'm sorry, I was taking a note. Which document are we on now?
This is version 1 of the validation variation.
Yes, yes. Thank you.
You have the policy.
I may be in the wrong bundle. Sorry. Can you give the bundle reference again?
My Lord, it's not in the bundle. It's a separate document that was sent in. I think sent in on Monday.
Yeah, yes, I'm sorry.
It's one of these purple things, validation.
Yes, okay, thank you.
This is the 6th of April 2017.
My Lord, yes. So you, on page 10 at the bottom, you have the subheading fee waiver or fee exemption and validation. That covers the circumstances of Afzal.
So which page, sorry?
Page 10, my Lord.
Yeah.
And we would place emphasis on the language in the last sentence. If they do not respond within that deadline, you must reject the application for leave as invalid.
And I'm sorry, I don't see this on page 10 at the moment.
I think it may be that we had two of those.
It's version 1, my Lord, not version 7.
Oh.
Apologies. Version 7 is the current one. We thought.
Oh, yes, I'm looking at version 7. So there's an earlier one.
Yes, this is the version that was applicable at the date of Afzal's application.
And just to check, does it say at the bottom of the page, published for Home Office staff on 6th April 2017?
My Lord, yes.
That's the what version you're looking at?
Sorry, can I have the entire page number? I haven't got PDF.
10 of 26.
Right. So this is an instruction to Home Office staff.
Yes, my Lord.
Yeah, I see.
And then, in relation to the IHS payment itself, if we go to the next page, there is a subheading, Requirement Immigration Health Charge Payment. And my Lords will see the full section on this, and the relevant part of it for the purposes of the appellant submission is the last paragraph, which is on the following page.
So page, sorry.
Page 12.
I see. So the earlier, what we were looking at a minute ago on page 10, that was to do with payment of a fee, was it?
My Lord, yes. That's the fee waiver. So if a fee waiver is applied for, and these overlap with each other, but it's important that one has a look at everything that's in the guidance that's relevant. So the fee waiver or fee exemption situation is covered at page 10. And then one has the situation where there's a requirement to pay the immigration health charge, but there might be a fee waiver, there might not be. I don't think it makes any difference to the overall process, because you can see from the last paragraph of that section, if an applicant has not paid the correct IHC, you may write to them and give them 10 working days to pay correctly. If they do not respond, you, again, should normally, so it's not that you must, you should normally reject the application as invalid. And we say that that is consistent with the appellant's construction on both grounds. So first of all, that it is the Secretary of State that does the invalidation, and secondly, the fact that even after the 10 working days, notwithstanding the language of Article 6, there is that overarching discretion in Article 8 that still bites.
This is the last paragraph above proof of identity.
But, my Lord, yes.
Yeah.
And the 22nd of January 2018 notice sent was in compliance with the invalidity template, was it?
Yes, my Lord. Yes, the appellant takes
It
no...
is ICD 4946.
Yes, there's no issue taken with that, my Lord. In that context, my Lords, if I could just come back to the sequence of events in the appellant's case. He applies in time for a fee waiver.
So can you give us dates as you're doing this? It would just be helpful to keep.
Yes. He applied on the 6th of July 2017 for a fee waiver. That was rejected on the 18th of October 2017. A follow-up letter purportedly sent on the 8th of November 2017. A notice of rejection on the 22nd of January 2018. And that letter, one can see in terms of the difference in quality between the reminder letter and the 22nd January letter, which again reinforces why it is such an important document. It spells out...
Which page?
This is at 305. It spells out at 306 the consequences, the liability to removal, the liability to detention, the consequences of staying in the UK unlawfully, and they're all bullet pointed. And my Lord, this is something that was set out at length in Mirza as well, the consequences, as well as Afzal.
I correctly understood your submission that this is the letter which decides the issue.
Yes, my Lord, yes. This is a letter that effectively invalidates the application, brings Section 3C leave to an end, and results in all of these consequences. And it is, in addition to everything else, important to look at the difference in the letters when one is construing which one has legal effect and which one, well, on the Court of Appeal's construction, this letter is simply notification of something that took place a few months ago.
And the consequence is that employers are potentially criminally liable if they are unaware of...
My Lord, yes, and hefty civil fines, etc. I think it affects landlords as well. Yeah. So it is an issue of importance not only to an applicant but to others, which is why one would expect that it would be governed by a properly regulated notification regime. My Lord, after this letter, we have an application made by the applicant within 11 days in February, on the 2nd of February, and that is, the covering letter is at 255.
How would the employer or the landlord benefit from the notification given to the applicant?
as far as the employer is concerned, there is, of course, the checking service run by the Secretary of State. But one would expect that if an employer is employing somebody who has leave to remain, if the employee knows that he no longer has the right to work, but doesn't inform the employer, that would form a defence. I don't know the ins and outs of that mechanism, but one can see from the letter that there are consequences for an appellant's right to do things, and there would be consequences for third parties. Now, how that actually pans out, my Lord, is something that we might have to look at and come back to you on in terms of the impact on employers. I'm sure it's not a straightforward issue, but there certainly would be an impact on third parties.
Well, I mean, it strikes me as fiendishly complicated, all of this. One might have thought that I'm interested to learn more about how employers actually check the position.
Yes, my Lord, we will look into that.
Ditto landlords.
Yes. And so, my Lord, we have the application on the 2nd of February within 11 days, which is at 255, where the application fee in the IHS is paid, and that application is then pending for 19 months and is eventually granted on the 5th of September 2019. There is absolutely no allegation of, and in fact no abuse at all on the part of this appellant at any time during the course of his immigration history. There is nothing to suggest that the non-payment of the IHS was deliberate. There was certainly nothing to gain for him because he had an application that was well-founded and was ultimately granted without the need for an appeal. His explanation, as I've already said, for not paying the IHS is that he did not appreciate that he was required to pay it. And my Lords will understand that rather than there being an abuse of the system, there is a detriment to the appellant now if this period does not count towards his period of long residence. If I could take my Lords to the Court of Appeal's judgment, which is at page 66. The relevant reasoning is at paragraphs 18 to 39.
Are there detriments over and above making sure you get to the 10 years? I mean, if the appellant in this case is in any event over the 10 years, what are we actually looking at in terms of detriment, if any?
My Lord, on the particular facts of this case, the detriment was the date on which he qualified for indefinite leave, and he had to make another application, paying a further fee and lawyers' fees, etc. And of course, the date on which you make an application makes a difference to the date on which you qualify for naturalisation. So on the facts of this case, the detriment was not so great. But that is only after the clarification of the position by the Court of Appeal in Afzal. If one goes by the approach adopted by the Secretary of State, there would have been a huge detriment because the clock would have reset to start in September 2019. So he would have qualified for ILR in 2029. So that clarification upon the challenge was of huge consequence to the appellant.
Right, but I mean, that's not an issue before us because the Secretary of State accepts that that's the correct approach.
My Lord, yes, I was just responding to my Lord's, my Lord's question. If one looks at, the reasoning is at paragraphs 18 to 39, I just wanted to draw my Lord's attention to paragraph 21. There is an error there, we say, in that the court considers that the fee waiver application was an application within Article 7, And we say that that is relevant because the rest of the judgment makes no reference to Article 8. And so the order was construed by the court without the benefit of considering Article 8 and the overarching discretion, and without appreciating that it was that discretion, that very discretion, that was sought by the applicant, the exercise of that discretion. And of course, my Lord, the court was hampered by a lack of submissions on this, because the parties put their case on two bases without this issue arising for decision on the way that the case was put. And my Lords will see the court's consideration of the case of Mirza and the reasoning at paragraph 26 that the difference between the outcome for Ehsan and the situation for Afzal was that the Secretary of State had a variety of options in Ehsan, but no such option in the case of Afzal.
Well, also, I hope you'll take us to Mirza, but my recollection is that the ASAM case was different because there wasn't a requirement to pay the fee at the outset. With, you know, in the other cases there was, and so the applications, because they were unaccompanied by the fee, were invalid from the outset.
My Lord, yes.
Whereas in the ASAM case, I think...
It was biometrics, my Lord. So
yes.
There wasn't a fee problem, it was a biometrics
Exactly.
problem.
And that was a subject, and the obligation to provide them only arose after a request was made by the Secretary of State, I think.
My Lord, yes. And the appellant's case before the Court of Appeal was that on that basis, the appellant's case was on all fours with Afzal. The Court of Appeal accepted that, and that's why the Court of Appeal found that Section 3C was engaged. The only dispute is when that leave came to an end.
Yes, I mean, it's dealt with very shortly in Mirza, but for recollection, obviously, the invalidity wasn't ab initio. It could only be from the time when there had been a failure to comply with the request of the Secretary of State.
My Lord, yes, that's absolutely right. And I will take my Lord to that next. And then, my Lords, at paragraph 34, the court concludes that the order provides for automatic invalidation. The court finds that there is no material difference between the language of not validly made in terms of the fees requirement for the first two appellants in Mirza and the language of must be treated as invalid in the IHS order. And we say that there is a material distinction, and I've already taken my Lord through the appellant's case on that.
So you say that in Mirza there weren't those four options, is that right?
No, my Lord. We say that in the comparison being made here is with the first two appellants in Mirza,
Yeah.
where the fee was required to be paid at the point of application. And if the fee wasn't paid, the regulations provided that the application was not validly made. And therefore there was nothing for the Secretary of State to do, because the application simply hadn't been validly made, and therefore it was invalid ab initio. Section 3C was not engaged. I'll take my Lords to Mirza, and my Lords will see the reasoning of the court on that. But
sorry, insofar as you're looking at paragraph 34 of the Court of Appeal, is that what you're engaging with?
33, my Lord.
Oh, 33.
The middle of 33, my Lord. This is where it's about halfway into a third into the paragraph. At that point, the position is akin to that in which the two appellants in Mirza found themselves.
Yeah. And you say this analysis hasn't taken account of Article 8 of the order, and the effect of Article 8 is that the Secretary of State has a discretion as to whether to invalidate or not. And so, in fact, we're in a similar position to Mrs. Ahsan
My Lord, yes, but also that it doesn't take account of the language of the order. And one can see at paragraph 33 that the only part quoted by the court is must be treated as invalid. But what is material is what follows. Must be treated as invalid by the Secretary of State.
Yep.
And that is consistent with the way in which the Secretary of State's own rules and policy operates this part of the immigration system. At paragraph 34, my Lord, the court again relies on the distinction between the fact that there is no option in the order, but there is an option under the biometrics regulations. But as I've already said, that distinction is of little relevance, particularly when one looks at subparagraph 3 of Regulation 23 of the biometrics regulations, which in the same language requires an application to be treated as invalid by the Secretary of State.
So, back to my question. You say that there weren't 4 different courses of action because the biometric regulations required under paragraph 3 the Secretary of State to treat the person's application for leave to remain as invalid.
No, my Lord. There were, well, the Supreme Court, if one looks at its judgment, and perhaps, my Lord, it's the right time to go to the Supreme Court's judgment in Mirza, which is at 982 of the bundle. And, my Lord, the reasoning in relation to the 4 courses of action is at 995, paragraph 37 of the judgment. And, my Lord, will see that the court was considering here whether the invalidation of the application had retrospective effect. That was the issue being considered. And what the court says about the language of the regulation is that it does no more than give the Secretary of State power to treat the application as invalid. And in the context of Regulation 23.2, the power to treat as invalid was discretionary. But if one looks at 23.3 of the same regulations, we have the same form of words, but with a power that must be exercised in a certain way. So the power is still with the Secretary of State to treat the application as invalid, but it must be exercised by treating it as invalid. What both the regulations of the order don't do is take the power away and exercise the power within the relevant piece of legislation. The power remains with the Secretary of State. It's just an instruction that this is how you must exercise the power. And this doesn't appear to have been an issue that was canvassed at great length before the Supreme Court, because the outcome in Ehsan was something that the Supreme Court came to itself, and this issue is not relevant to the Supreme Court's reasoning, because, as I say, the reasoning was in relation to retrospective invalidity. But there is a question mark as to whether it was 23.2b that applied in Ehsan's case or 23.3.
Well, the court didn't consider 23.3, did it?
My Lord, no. But it's not material to the outcome, but we say that in Afzal's case it's clearly 23.3 that would apply by virtue of 23.1, which makes 23.2 subject to paragraphs 3 and 4 of that subsection.
23.3 doesn't confer a power it imposes a duty.
A duty to exercise the power in that way.
Well, the Secretary of State must treat as invalid.
And again, we come back to the point, which is that the Secretary of State is doing the treating. The regulations aren't doing the treating. The regulations aren't invalidating. The order isn't invalidating. It's simply giving an instruction that this is how you must exercise your power. And that makes sense because it's an instruction given by the Secretary of State to her own caseworkers.
So you say Sir Patrick Elias goes wrong by focusing on the automatic nature, and you're effectively saying that's actually an incorrect analysis.
Well, my Lord, we say that even if it is automatic, where Sir Patrick Elias went wrong was to not consider the words that follow must treat as invalid by the Secretary of State. So it must be treated as valid by the Secretary of State. The mechanism is that it's the Secretary of State that does the invalidation. And that is the mechanism used in the biometrics regulations.
Okay, that would seem to me to be non-automatic, but...
My Lord, yes, non-automatic by operation of law, because the Secretary of State must still do something. But whether there is a discretion at that point or not is not essential for the appellant's submission. We say that there is, but even if there isn't, the power must still be exercised by the Secretary of State.
So it's non-automatic in two senses. One, there's a discretion, and two, in any event, it requires action by the Secretary of State.
My Lord, yes.
Yeah.
So, in a nutshell, treat as invalid requires the taking of a positive step to invalidate.
My Lord, yes. Because it's the Secretary of State that must do the treating. That's the terminology in both the regulations and the order. If that terminology had not been present, the argument would be different, but it is there and it's important. And my Lords, just going back to Mirza, it is important in my submission to re-emphasise the concerns by all parties, the court, the appellants and the Secretary of State in the course of those appeal proceedings. If I could take my Lords to paragraph 15.
Page, please.
Page 989.
Thank you.
And it was Lord Justice Elias, as he then was, at the Court of Appeal in Mirza. At paragraph 15, one can see that the Secretary of State herself had concerns in relation to the way in which the invalidation provisions were working.
I'm sorry, paragraph 15 is a submission on behalf of Mr. Afzal, isn't it?
My Lord, sorry, I'm at 989, the Mirza judgment.
Oh, I'm so sorry. I'm so sorry.
Apologise.
Looking at the wrong judgment. Right. Yes.
In relation to the positive act that you say has to be taken by the Secretary of State,
Yes.
What exactly is it?
The sending of the notice, my lord.
But is that the sending of notice is notification? But are you saying that the Secretary of State has to make a decision that it's invalid?
My lord, a decision has to be made, but either there is a discretion, or if there is no discretion, then she must make that decision. That is a matter for my lords. We say that there is a discretion, but either way, the point that is pertinent for the purposes of the issue before your lordships is that that must take place by written notice by the Secretary of State. And there isn't a distinction, I think, per previous case law, and with Section 4 of the 71 Act applying in these circumstances as well. There isn't a distinction between a decision and the notice. The notice is the manner in which the decision is made, so the manner in which the power is exercised.
And what is the decision that's made?
To reject the application as invalid, which is what the 22nd of January notice did.
I understand your submission actually to go further than that, because in answer to questions I asked earlier on, you said it's not just drawing up the notice, sending the notice. These are all actions by the Secretary of State. It's actually receipt by the applicant, which isn't an action of the Secretary of State at all.
My Lord, yes, well, it is, in the immigration context certainly, settled law that a notice that is sent is not effective until received. And of course there are deemed receipt provisions, and there is a whole section of case law on that. But that is also the way in which Appendix SN is drafted, with deemed receipt provisions, and if a person doesn't receive it, then that notice is ineffective. But that isn't the case here. There is no suggestion that he did not receive it. He received it and he acted upon it. But the decision is made by the Secretary of State. It's made by way of notice. It's notified. But it doesn't take effect until it is received or receipt is deemed. And that is why there is the full mechanism under Appendix SN as to how one sends out these notices. And of course, and this is in the written case, the difficulty with the way in which Article 6 is construed is that we're looking at a situation whereby the request has been made in writing, so that there is a letter that one can pin a date to. But it becomes conceptually more difficult if the request is made by telephone or in person, which the order envisages, which, in my submission, makes it more likely that the construction the appellant advances is the actual intention of the legislation, not that a telephone call or a face-to-face request, which isn't noted anywhere, apart from perhaps in the Secretary of State's own system, if it is noted there, can result in such grave consequences. And my lords, the concerns that are outlined at paragraph 15 of Mirza, which were raised by the Secretary of State before the Court of Appeal, are concerns that apply equally here. They are the same concerns, and the appellants submit that the construction advanced by him addresses these concerns, and the construction favoured by the Secretary of State, or she supports the construction of the Court of Appeal, means that these concerns remain live. Three concerns set out which contain a number of difficulties. The discussion then begins at paragraph 30. The court said that this was a troubling case and that there was an inability to maintain a consistent view of the meaning of the rules and regulations by the Secretary of State, and how important it was, particularly in the case of Section 3C. At 31, the policy concerns which underlay the Secretary of State's position in the Court of Appeal were and remain very real. And then in relation to Ehsan, which is relevant for our purposes, the court at 36 and 37 found more difficulty with that case, but ultimately held that Section 3C was engaged because the requirement to apply for biometric information arises at a later stage on receipt of a notice from the Secretary of State. As I've said earlier, the Court of Appeal accepted that part of the appellant's submission and held that Section 3 was engaged. That is not an issue before my Lords. And then at 37, the court concludes the natural reading, which is consistent with the statutory purpose, is to give power to invalidate the application as from the time of the decision, but not before. My Lords, the appellant makes three submissions as to why the Court of Appeal's conclusion on this issue is wrong. The first we've already dealt with, which is that the construction is inconsistent with the reasoning and outcome in Mirza for the appellant Ehsan, and inconsistent with the language of the 2015 order. The second submission is that it is inconsistent with Section 3C 2A. And if I could take my Lords back to 712. Once Section 3C is engaged, the appellant submits that it can come to an end by one of the routes envisaged by the section itself, and that would have to be when the application is decided. The appellant says that rejecting an application as invalid is a decision. The Secretary of State's case is that it is not a decision. There needs to be a substantive decision in order to bring it within Section 3C 2A. Appellant says that there is nothing in that section that refers to a substantive decision. It just refers to an application being decided. And that could be decided by way of invalidation, rejection because it's not for a purpose covered by the rules, or any of the ways in which an application results in an outcome. And an outcome that it is an invalid application is a decision. The appellant says that the Secretary of State's construction requires reading words into the section, and there's no reason to do that. And if one did have a situation whereby Section 3C did not cover the situation of invalid applications, there would be a gap in the provision made by Section 3C, and that cannot have been intended by Parliament. And the third submission in relation to the construction of 3C, and they're all freestanding, so my Lords might reject one or two but accept the third. So the construction of 3C2A is not necessary for the appellant's case. If the Secretary of State is right and the Supreme Court in Mirza was saying that Ehsan's Section 3C leave came to an end not by operation of 3C but by some other means. Those other means apply in this case as well. The leave has to come to an end at some point. And we say that point is the point at which the notice is served, exercising the Secretary of State's power to treat the application as invalid. And the third submission relates to Anufrijeva. And if I could take my Lords to Anufrijeva now, which is at 1030 of the bundle.
I'm sorry, which page?
1030, my Lord, and if I could take my Lords to 1044, which is the judgment of Lord Steyn. Lord Steyn gave the leading judgment for the majority.
I beg your pardon, I've missed the page.
1044 is where the judgment begins, my Lord.
Yes, I've got it now, thank you.
And if I could take my Lords to 1046, paragraphs 25 to 27 are the core reasoning with respect to right of access to justice. And at 27, the consequences of those principles for interpreting. And where the submission ends up in relation to those paragraphs is the extract from the Sims case at paragraph 27. About a third of the way into the extract, fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. So we say that principle applies when one looks at Article 6 of the order, and we further rely on paragraphs 28 to 30, which relate to the rule of law being observed. And at 28, the second sentence sets out the submission. That principle too requires that a constitutional state must accord to individuals the right to know of a decision before their rights can be adversely affected. Lords Hoffman, Milliton, Scott all endorsed Lord Steyn's judgment. Lord Scott gave additional reasons at paragraph 58. And if I could also refer, my Lords, to paragraphs 54 and 55, where the legislation is construed in the context of the statutory scheme of which it forms part. And at 55, the context must be construed, that against which provision must be construed, also consists of the immigration rules. And of course, my Lord, I will ensure that we provide the rules as they were at the time that the order came into force. My Lords, those are my submissions in relation to Section 3C, subject to any questions my Lords have.
I'm just looking at Section 3C itself. I'm afraid I don't know what page it's on, but
712.
712, my Lord.
We're told in subsection 1 this section applies if a person who has limited leave applies for variation. The application is made before the leave expires, and the leave expires without the application for variation having been decided. So you say that those requirements are all met in the present case.
My Lord, yes, and that is not a matter that is in dispute.
And then under subsection 2, the leave is extended by virtue of this section during any period when A, the application is neither decided nor withdrawn, and you effectively, I suppose, the Court of Appeal have said that if the application must be treated as invalid under Article 6, then there is no longer an application for the purposes of 2A, and it follows that the leave can no longer be extended by virtue of Section 3C.
My Lord, I might be mistaken, but my recollection is that the Court of Appeal doesn't address this.
No, well, no, they don't. That's really why I'm. That's one reason why I'm raising it with you. Your approach, I think, is to say that the period when the application for variation is neither decided nor withdrawn continues until the Secretary of State decides to reject the application as invalid.
My Lord, yes. And as I understand it, the Secretary of State's position is that that is not a decision within the meaning of the subsection, and therefore one is governing the end of Section 3C out with the requirements of 3C, which we say that doesn't make sense, and this makes more sense.
And as I understand your submission, that decision is made on the 22nd of January or at the point that letter is communicated to?
My Lord, yes. Ordinarily, my Lord, if one looks at Appendix SN, the date of the letter is the 22nd of January. Deemed receipt is 2 days thereafter, so it would take effect 2 days after posting.
Yes, thank you.
My Lords, shall I move on to issue 2?
It looks as though you can.
Yes, I'm grateful. My Lords, this issue is the subject of two relevant Court of Appeal judgments which are in conflict with each other, the judgment in Hock and the judgment in Afzal. There is also a third judgment which, although not of the elevated authority of the Court of Appeal, is still an important judgment because it's a judgment of the upper tribunal which is reported, and therefore it comes with the endorsement of the upper tribunal's reporting committee. I was intending to, I think perhaps if I take my lords through some of the documents in the bundle that relate to the history of the long residence provisions, and then come on to the judgments in Hock, Munib Asif and Afzal in chronological order, so that one can see how this issue is developed. My lords will perhaps be aware, I think it's set out in the cases that were made down below and here, that the long residence rules began as an extra statutory concession. And we have an early version of it at 1295 of the bundle. And at that time, the long residence concession related to two periods of long residence, 10 years of continuous lawful residence and 14 years of residence, which could be a combination of lawful, unlawful, or entirely unlawful. My lords will see the background is set out. The concession is based on the European Convention on Establishment. And then, for the purposes of the issue that is before the court, subsection 3 of that concession, the bottom of 1295, headed lawful residence. And the strictness with which the policy and then the rules have applied the lawful residence provision has varied over time. I think that's partly to do with the fact that there was also the 14-year long residence rule, and therefore any gaps in lawful residence could be remedied after 10 years by use of the 14-year period, and also based on the changing policy of the rules overall, in particular from 2012, when the exceptions for overstayers policy came into the immigration rules, which was an overarching policy covering all applications. There was a significant impact on the long residence provisions, and in fact, the provisions became more generous in terms of gaps in lawful residence. But what we say is important in terms of this version of the long residence policy is that it is clear that where there are gaps in lawful residence, those gaps, if they are permitted to be ignored, should be counted. So, when considering whether a person has remained in the United Kingdom lawfully for 10 years, the following breaches of conditions may, for the purposes of this concession, be considered as lawful. Then you have a short delay in submitting an application, providing that it is granted. Any period between submission and determination of an appeal, if it is successful, and where an appeal is unsuccessful but leave is subsequently granted, the period between submitting the appeal and the determination will be treated as lawful. And then the time I&D take to decide and inform the person of the outcome of an in-time application should be included as continuous lawful residence, because at that time there was no Section 3C, and therefore that was also counted as lawful residence. But the exceptions here in my submission are clearly intended to count as lawful residence, not to be ignored, so that they pause the clock. on the 10 years lawful residence requirement. I could then take my lords to 1306. This is the April 2009 instructions to caseworkers. At the bottom of that page you have the section breaks in lawful residence and the use of discretion. And the first sentence on the following page, 1307, and the last part of the third paragraph in my submission illuminate the core principle that the policy has always sought to apply when it comes to considering any gaps in lawful residence.
Which passage are you directing us to?
So, my lord, the first sentence at 1307,
yes.
Caseworkers should be satisfied that the applicant has acted lawfully throughout the entire period and has made every attempt to comply with the immigration rules. And then the third paragraph, it would not usually be appropriate to exercise discretion when an applicant has more than one gap in their lawful residence due to submitting more than one of their previous applications out of time, as they would not have shown the necessary commitment to ensuring they have maintained lawful leave throughout their time in the UK. So that is the core principle that the policy and the rules in my submission are seeking to give effect to.
So am I right in thinking at this time, at the time of these instructions, this was a matter for discretion of
My Lord,
caseworkers? Yes. So this is telling the caseworkers how ordinarily they should exercise.
My Lord, yes. And it was a very tightly regulated discretion. One can see that one short gap is permitted, more than one gap, and that is not permitted. The rules are now far more generous, but that is in the context of the overall scheme of exceptions for overstayers, and of course the taking away of the 14-year rule as well. So we don't have the 14-year option, the 10-year option is there, but if you have short gaps, the rules are now more generous. But we say that the fundamental principles still apply, which is that one is looking for applicants that have shown a commitment to staying within the rules.
But, I mean, you say the rules are more generous, but as I understand it, under the current scheme, it has been made a matter of rules, not discretion.
My Lord, yes.
It's purely a matter of construing the rules, isn't it? I understand that you're showing us this as...
My Lord, yes. There is still discretion in the policy guidance, but we're not relying on that. This case is about the application of the rules and whether disregard means that you disregard the overstaying or you disregard the period. And my lords, just to re-emphasise this fundamental foundation of the policy, if one goes to 1334, the July 2012 version of the guidance, again under the subheading discretion for breaks in lawful residence, you must be satisfied that the applicant has acted lawfully and has made every effort to obey the immigration rules.
So, sorry, where's
that?
That's halfway down the page. This is 1334 under the subheading discretion for breaks in lawful residence.
And specifically, we're now looking at which document?
You must always discuss the use of discretion of a senior caseworker.
Yes, and then the next sentence, my lord.
Ah, yes, yes. It's slightly difficult to read, but it's been compressed.
Yes.
I think electronically.
Sorry, and the date of this?
My lord, the date is at the bottom right-hand corner, valid from the 11th of July 2012.
Thank you.
And my Lords, then at 1398, and this is repetitive, but I just wanted to show my Lords that this is something that is a consistent theme. You have the October 2012 guidance, and again, under the subheading discretion for breaks in lawful residence, the second sentence is the same. I won't take you through the other versions of it, but my Lords get the point that I'm trying to make, which is that this is something that has existed in the provisions as a foundation of the overall policy.
Just going back to the July 2012 document at page 1334, if an applicant has acted lawfully the whole 10-year period, then presumably they have made every effort to obey the immigration rules. And if they haven't acted lawfully, then...
My Lord, bearing in mind that the sentence envisages somebody acting unlawfully, making every effort to obey the immigration rules, not obeying the immigration rules is not construed as unlawful. And I would think that when one is saying lawful behaviour, one is talking about criminality in particular. Although my Lord is right, if one looks at the consequences of becoming an overstayer, as set out in the 22nd of January notice and as set out in the Supreme Court's decision in Mirza, there is potential for a lot of illegality. But in this context, what one is looking at is an applicant that has behaved properly and behaved within the spirit of the Secretary of State's immigration system of immigration control. And I think it is best expressed at 1307 in the third paragraph, the commitment to ensuring they've maintained lawful leave. So somebody that is reckless about whether they come within the Secretary of State's system of immigration control is not deserving of the exercise of discretion, but where somebody has shown that commitment but nevertheless fallen short, there is the potential for exercising discretion.
So is it this system of discretion which Rule 39E then replaces?
My Lord, yes.
Right.
Although there is still discretion beyond 39E, as one will see from the policy guidance, but yes. And it is a system that is more generous than the previous system, as my Lords will see. If I could then take my Lords to the immigration rules, the 276A is at 770. This is the version that was in force at the date of Afzal's decision. And my Lords will see that at 276A we have a definition of continuous residence in subparagraph A, and then what is relevant for our purposes, which is subsection B.
And I'm so sorry, my fault. Page number?
770.
Thank you.
I remember there was a case in this court, something like 10 years ago, where we held that some of the things which were in IDIs ought to be properly in the immigration rules.
Yes.
Is that the reason why this got translated from guidance into the rules?
My Lord, yes, that is, I think, why we have so many appendices.
Yes.
So the appendices are part of the rules, but that is the way that the rules have now been structured.
Yeah.
My Lord has in mind the cases of Alvi and Munir.
That's right. Yes, I did. Yeah.
And so, my Lords, at 276A we have the definition of continuous residence, but then, as pertinent for our purposes, the definition of lawful residence, which is at the top of page 771. And my Lords will see in particular that lawful residence means residence pursuant to existing leave to enter or remain, which is very easy to understand and follow, but also that for the purposes of 276B, lawful residence means temporary admission within Section 11 of the 71 Act, or immigration bail within Section 11 of the 71 Act, where leave to enter or remain is subsequently granted. And that is an important concept when considering what disregard means in the rules, and we say that the Court of Appeal did not take this into account and only focused on B1 when B2 was relevant and is consistent with the way in which the appellant says disregard works. So it's not an aberration from the definition of lawful residence. It's a natural extension of it. And this can, I think, best be illustrated by looking at the example in the Secretary of State's policy guidance as to how this operates in practice. I'll just take my Lords to the guidance that was in force at the date of the decision in this case. I think it's version 16, which is at 1687. And if I could take my Lords to 1707.
This version I see is published in October 2019.
My Lord, yes, so it was current at the date of the decision in Afzal in March 2020.
Right.
So, sorry, when you say decision, whose decision are you?
Afzal, my Lord.
Yeah, but whose decision? Because
The Secretary of State's decision in March 2020, my Lord.
Right. Okay.
Was it 2020?
Decision to refuse it.
Decision to refuse indefinite leave. So that's the point at which.
So, right, 11th of March 2020.
My Lord, yes. But this particular example applies throughout all of the guidance. It's an example of the way that the temporary admission definition in 276A(b)(2) works.
Which page are you taking us to?
My Lord, it's 1707. If I could ask my Lords to just read this page, it is, we say, fundamental to the issue that is before the court.
Why do you say it's fundamental for the issue before us? Because this is part of the implementation of the definition of lawful residence. So if you satisfy this, you don't have a problem with any gap in your continuous lawful residence.
My Lord, yes. But when one is construing what disregard means, when one looks at Sir Patrick Elias's reasoning, he sets out three fundamentals and then how the construction advanced in hoc is inconsistent with that, and we say that he erred there, and one of the ways in which he erred was he failed to take into account the way that temporary admission is converted into lawful residence for the purposes of the rule, which is consistent with what would happen if the disregard operated to count this residence. So if we look at the example...
But this is part of a rule which specifically defines what counts as lawful residence in the first place.
Yes.
So if you're within this rule, you don't have a problem with a break in your continuous lawful residence.
No.
Sir Patrick Elias was looking at a rule addressed to a different context where you do have a problem with a break in your continuous lawful residence, and what does disregard mean in that context? And I think what I'm struggling to understand at the moment is why you say we get assistance on that latter question from looking at the definition of lawful residence.
Well, my Lord, can I come back to that, and I'll take my Lord through that point when we look at the judgment.
All right.
In summary, and I know that we're, I think, about a few seconds away from 1 p.m. I wonder if this might be a convenient moment to stop and we can continue.
Yes,
I'll take it up there, my Lord.
Yes, if that's convenient for you, Mr. Jafferty, then by all means, we'll resume at 2 o'clock.
I'm grateful.